111. The President, in publishing laws and decrees, shall use the following form: the President of the United Mexican States, to the inhabitants of the Republic, knowing that the General Congress have decreed the following. Here the subject: therefore, I command that it be printed, published, and circulated, and that due compliance be given at 112. The restrictions of the faculties of the President are the following. First, the President cannot take command of the forces by sea or land in person, without the consent of the General Congress, or should it not be in session, without the Council of Government, by a vote of 2/3 of the members present. When he takes command of these requisites, the Vice President shall administer the government. Second, the President has not the right to deprive anyone of his liberty, nor inflict punishment on any individual, but when the safety of the Federation requires it, he can arrest any person provided he places the person arrested, within 48 hours, at the disposition of the competent judge or tribunal. Third, the President cannot occupy the property of any individual or corporation, or disturb the possession, use, or benefit of it, and should it be necessary for the public good to take the property of any individual or corporation, it will require the approbation of the Senate, or in its recess, the approbation of the Council of Government, indemnifying the party interested by the decision of men chosen by the party and the government. Fourth, the President cannot impede the elections and other acts expressed in the last clause of the 38th article, Section 5th, of the Council of the Government, 113. During the recess of Congress there shall be a Council of Government, composed of 1/2 of the members of the Senate, one for each state, 114. For the first 2 years, this Council of Government shall be composed of the first members elected by their respective legislatures, and the succeeding year by the oldest members, 115. This council shall have for President the Vice President of the United States, and also have the power to elect a President pro tem to fill the vacancy occasioned by the absence of the other, 116. The attributions of this council are the following. First, to see that the Constitution is strictly observed, and the Constitutional Act and general laws, and to give their advice in any incident relative to these objects. Second, to lay before the President any observations conducive to the better enforcement of the Constitution and laws of the Union. Third, to determine of themselves only the advice of the President, and the calling of extraordinary sessions of Congress, but in either, it shall require the vote of 2/3 of the councilors present, as stated in Attributions 17 and 18 of Article 110. Fourth, to grant their consent to the calling out of the local militia, in the manner stated in Article 110, Attribution 11. Fifth, to approve the appointment of officers designated in Attribution 6 of Article 110. Sixth, their consent in the case referred to in Article 112, Restriction 1st. Seventh, to name 2 individuals who shall, in conjunction with the Chief Justice of the Supreme Court, provisionally exercise the supreme executive power as prescribed in Article 97. Eighth, to administer the oath stated in Article 101 to those individuals of the supreme executive power in the terms provided in this Constitution. Ninth, to give their opinion on subjects referred to them by the President by virtue of the 21st faculty of Article 110, and all business wherein he may consult them. Section 6 of the Dispatch of Government Business, 117. For the dispatch of government business of the Republic, there shall be the number of Secretaries of State which Congress by a law may establish, 118. All the regulations, decrees, and orders of the President must be signed by the Secretary of State of the departments to which the subject belongs, and without this prerequisite they shall not be obeyed, 119. The Secretaries of State shall give to each House, as soon as their annual sessions are opened, an account of the state of their respective departments, 120. The Secretaries of State shall be responsible for the acts of the President, unauthorized by their signatures, contrary to the Constitution, Constitutional Act, and general laws and constitutions of the states. SDCT, 121. To be a Secretary of State it is necessary to be a Mexican citizen by birth, 122. The Secretaries of State shall form a regulation for the better distribution and direction of their duties, which shall be passed by the government to the Congress for their approbation. Title 5, Section 1st of the Judicial Power of the Confederation, 123. The judicial power of the Federation shall reside in one Supreme Court of Justice and in the Circuit and District Courts. Section 2nd of the Supreme Court of Justice, the election, term of service, and oath of its members, 124. The Supreme Court of Justice shall be composed of 11 members divided into 3 halls and 1 Attorney General. Congress may augment or diminish its number as it may deem necessary. 125. To be elected a judge of the Supreme Court of Justice, it is necessary to have been instructed in the science of public rights, according to the judgments of the legislatures of the states, to be 35 years of age, to be a native-born citizen of the Republic, or born in any part of America, which in 1810 was dependent on Spain, and has separated from her, provided they have been 5 years resident within the territory of the Republic. 126. The judges of the Supreme Court of Justice shall hold their offices during good behavior, and can only be removed in the mode prescribed by the laws. 127. The election of the judges of the Supreme Court of Justice shall be made on the same day by the legislatures of the states by an absolute majority of votes. 128. The elections concluded, each legislature shall remit to the Council of Government a certified list of the 12 persons elected, designating which one of them was elected the Attorney General. 129. The President of the Council, as soon as he shall have received the lists from at least 3/4 of the legislatures of the states, shall give them direction indicated by the rules of the Council. 130. On the day designated, the Congress shall open and read the said lists in presence of both houses united, after which the Senate shall retire. 131. In continuation, the House of Representatives shall appoint, by an absolute majority of votes, a committee, which shall be composed of 1 member from each state, from which there was any member present, to which committee the said lists shall be passed, who will revise and examine them, and render an account of the result, and the House shall then proceed to class the election, and count the votes. 132. The individual or individuals who may have received more than half the votes of the whole number of the legislatures, without regard to the number of votes given by their respective members, shall be considered elected, and the declaration of the House to that effect shall immediately entitle them to their seats. 133. Should those who may have received the necessary majority of votes agreeably to the last article not amount to 12, the House shall elect the balance from those who had the highest number of votes, before the legislatures, observing in everything relative to these elections the provisions of the first section of the 4th title, which treats of the election of President and Vice President. 134. Should a senator or representative be elected a judge of the Supreme Court of Justice, his election to that office shall be preferred over the other. 135. When a vacancy occurs in a Supreme Court of Justice, by perpetual inability, it shall be filled agreeably to this section, after a previous notification given by the governor to the legislature of the state of said vacancy. 136. The members of the Supreme Court of Justice, or entering upon the exercise of the office, shall take an oath in the presence of the President of the Republic, in the following form: you swear to God our Lord, faithfully to discharge the duties and obligations confided to you by the nation. If you do this, God will reward you. If otherwise, he will punish you. Section 3rd of the Attributions of the Supreme Court of Justice. 137. The attributions of the Supreme Court are the following. First, to take cognizance of the difference which may arise between one and another state of the Federation, whenever it embraces a subject of litigation, in which there must be a formal sentence, and those that arise between one state and one or more inhabitants of another, or between individuals about pretensions to lands under concession from states, without depriving the party of the right of reclaiming the concession from the authority which granted it. Second, to terminate all disputes which arise, or contracts or negotiations made by the Supreme Government, or its agents. Third, consult relative to publishing, or retaining of pontifical bulls, briefs, and prescripts issued in matters litigant. Fourth, adjust any dispute that may exist among the tribunals of the Federation, and between these and those of the states, and these which may arise between the tribunals of one state and those of another. Fifth, to take cognizance, first, of the prosecution moved against the President and Vice President according to Articles 38 and 39, after the previous declaration in Article 40. Second, of the criminal prosecutions of the representatives and senators, indicated in Article 43, after the previous declaration required in Article 44. Third, of those against governors of the states in the cases spoken of in Article 38, in its third part, after the previous declaration required in Article 40. Fourth, of those of secretaries of state in conformity with Articles 38 and 40. Fifth, of the civil and criminal affairs of the diplomatic ministers and consuls of the Republic. Sixth, of the Admiralty cases, captures by sea, land, and contraband, of crimes committed on the high sea, of the offenses against the United Mexican States, of those employed in the Treasury and Judiciary of the Federation, and of the infractions of the Constitution and general laws, as may be provided for by law,